Well, thank you very much for the invitation. It is a pleasure to be here today. Even if we are not aware of it, we are surrounded by IP on a daily basis. I mean, even in this room, there are different IP rights. Let me exemplify this with a concrete example. If I take my wristwatch, it has a movement that allows it to measure time. This is a technical invention. And if it is new and inventive, it might be protected by a patent. You also have a name or logo of the watch, which is as a rule protected by a trademark. You also have design aspects of the watch, may it be the watch case or the bracelet, and then you can enjoy design protection for these elements. And I would say for quite a large number of watches, you have a very small mention that says Swiss made. This is a protection of indication of origin. You need to fulfill certain criteria to be able to write Swiss made on your watch. Concretely, it must be mainly manufactured in Switzerland. And last but not least, you might have a catalog or an advertising slogan for the watch, and these are protected by copyright. If you look at patent, it is about a new invention. And the protection it gives you with the patent is to allow you to put free riders away. If you bake bread, you only have one person that can eat your bread. If you invent something, somebody else can see it and say, oh, that's a great idea, I'll just do exactly the same without having to invest all you invested in research and development. And with IP protection, you can turn your ideas into assets, which allows you to go to market and benefit from them. If I look at trademark, it's a slightly different protection in the sense that there it is more about your reputation. You invest also in your reputation. You want to have a quality product. You want consumers to recognize it with the packaging, but also with with a specific taste or way of looking. And you don't want other companies with a different product or not as good product using your trademark, and then the customer or the consumer will buy it thinking it is your product, but it is not, and then be disappointed with the result. When it comes to copyright, it is similar to patents. You had a creative idea, you wrote something new, be it a text or a song, and you also want it to be yours and to be able to market it and not have somebody else do the same and earn money with your invention or creativity. Well, the short answer to the economic importance of IP is it's huge. If I elaborate a little bit on this answer, you can look at different elements. I mean, if you look at the 500 biggest companies on the US stock market, in the 70s, about 17% of the assets were intangible assets. If you look at these companies today, it's 90%. So we've seen a shift in the economy away from physical goods to intangible assets. And IP has a huge role when it comes to intangible assets. Also, if you look at the added value, the companies that provide the biggest added value to the economy are so-called IPR intensive companies or areas of the economy. IP protection, it is a give and take. When you apply for patent protection and your patent application gets registered, you get a protection which allows you to keep competitors out of the market. It gives you a monopoly for a certain time, up to 20 years. But you also have to give to get that protection. And the give is that you have to publish your invention, which then becomes available on a worldwide basis. People can research it. And it is the basis for further research, which allows other people to continue researching and develop something new, building upon your invention. And so you need to find a balance between these different interests. If you have too little IP protection, you don't have the incentive to innovate. Why should I innovate if everybody can use my invention without having to invest in research and development? If you have too much IP protection, you block a lot of market competitors, because as long as patent protection is up and running, others are not allowed to use that same invention on the market. So you need to find a balance between all these different elements. Well, the Institute of Intellectual Property has different tasks. I would say the main task is the administration of IP rights. If you want to have a trademark protection in Switzerland, you have to deposit an application with us, and we have quite a large number of colleagues that will check your application and determine whether it fulfills all the legal requirements to be registered. We also not only look at application, but at IP rights during their lifetime. For example, if you have a patent with us, we will send you a bill on a yearly basis. And if you don't pay the bill, or if 20 years have elapsed since your patent application, we will then delete your patent from the register, as you no longer have patent protection. So this is one of the very important tasks, and it is also the one that requires the largest number of people, resources in the institute. It is also the largest income base of our institute. Another very important aspect of our work is the policy work. We are the center of competence for all IP-related questions in the federal administration. We counsel the Federal Council and Parliament, so we will prepare legislatory amendments, we will prepare the responses to parliamentary questions, to all IP-related aspects. But we're also active at the international level, in the sense that we represent Switzerland in the different international organizations that deal with IP. At the forefront, WIPO, but also other organizations like WHO or WTO that also deal not mainly, but partly with IP-related aspects. And their role is to bring in the Swiss position on the different international issues that are being discussed. Well, it is true that the economy is becoming more globalized, but if you want IP protection, you still have a territorial approach. I think that is historical. I mean, law is territorial. You have sovereign states that are allowed to set up their rules. At the same time, IP is one of the areas where early on there was a pressure or a need to harmonize at the international level, considering the international activity at the economic level. So you have a large number of international agreements that allow for this. If I look at the global system, for example, if you want a trademark and you already know that you're going to be active in several countries, you can deposit your application with WIPO, who will then dispatch it to the national offices, and each national office will have its examination. But still, you have a single spot of entry, which then allows you to obtain your protection. In the patent system, even more has been done at the European level, as we have the European Patent Organization, which allows you to have your patent application, which will be examined only once by the EPO. And then you can decide in which of the member countries or associated countries you want to have patent protection. And then you receive a national bill from the different offices, but still only one examination instead of several, depending on the country. And we're expecting now in 2022 to have the unified patent enter into force. It will allow you to not only have one patent examination, but also only one patent fee for almost the entire European Union. Switzerland is not part of the European Union, so we will not be part of the unitary patent. but Swiss patent holders will still benefit from it because they are active also on the European market and will have the possibility to apply for such a unitary patent. Well, there are quite a few issues that keep us busy, but I can maybe center on recent activities also surrounding the COVID pandemic, which has kept not only you, but all of us very busy. At the national level, we offered assisted patent searches. This is a product that we've been offering for quite some time, but that became very attractive during the pandemic. We had a high surge in demand. I think it reflects several aspects. For one, I mean, if you have a new challenge like the pandemic was, you need to find new solutions. You need to be innovative. And it was very positive for us to see how the economy was reacted. And there were weeks we had up to 70 assisted patent searches per week, which is quite a larger number than we usually have. At the international level, one of the big discussions that was initiated was around the so-called TRIPS waiver proposal made by India and South Africa. They want to suspend the rights accorded by the TRIPS agreement, in arguing that it is preventing overcoming the pandemic. And this is a discussion we have been a part of since it was initiated, and which takes quite some time. Well, at the beginning of the pandemic, we were quite unsure how things would develop. So we looked at crises from the past, for example, the financial crisis. And based on that, we were expecting patent applications to keep steady for a little bit and then fall, because usually if you're already on the brink of patenting something, then that's not the point you will stop, but you will maybe invest less in future innovation. And on the trademark level, we were expecting a sharp decline and then a slow but hopefully steady recovery over the years. And in fact, it came differently in the sense that patent applications have remained steady. We have not seen any decline so far, so we hope that this will continue to go this way and reflect the innovative activity of the economy. And in the areas of trademark, instead of a decline, there was a sharp increase. We had last year plus 16% of trademark applications, which also shows that people, the economy is working. And there was also a shift onto online platforms, which require sometimes trademark registration to ensure that you don't have fakes on their platform. Well, the question in a nutshell is IP an obstacle to overcoming the crisis, or is it helping overcoming the crisis? And the Swiss position is very clear on that. It is helping overcoming the crisis. Let us look at some of the facts. I mean, I've got my booster last December. I think we were all very impressed about how quickly vaccines were developed. At the same time, we need to be aware that these vaccines were not developed from scratch, but building upon research that has been happening for years now. And I think without the incentive to innovation that patent protection affords, I'm not sure that this research would have happened, and then we would have been in a totally different position to develop these vaccines to combat the COVID pandemic. Another aspect of IP protection is it gives you a framework for collaboration. And we saw this with the whole manufacturing question. Obviously, at the beginning, there was not enough manufacturing capabilities. To build these manufacturing capabilities, you needed companies to work together. They needed to be able to share information about, how does the vaccine work, what are the requirements for production. And with IPR, they had a stable framework to do this, to have licensing agreements, to have confidentiality agreements, or whatever they needed to be able to collaborate. And this has allowed us to go from 0 vaccine doses to, I think, currently over 1 billion that are being produced on a daily, not on a daily basis, but on a yearly basis. With all these vaccines that are being produced, now if there is a lack of vaccine somewhere, it's not a question of manufacturing, but it's a question of distribution, of logistics. But all these questions have nothing to do with IP. So in a nutshell, I mean, IPR is part of the solution, and Swiss position will continue to defend that also at the international level. Well, the big copyright revision we had, and which entered into force now almost 2 years ago, the main goal was to make copyright law fit for the digital age. So we had to amend the laws or the rules on copyright infringement and how we fight them online. We also included clauses to facilitate access to work. And we discussed before the international dimension of intellectual property. It was about accessing to new international agreements on copyright. That might all sound a bit abstract, so let me give you a concrete example. Mining. Obviously, Switzerland is not a mining country. We don't have many natural resources. But we do mine, and this is data. Data mining has become more and more important in the last few years, not only in the industry, but also in the research area. One of the obstacles is that if you mine data, you need the data. But can you use data that is in a publication that is protected by copyright? So there was a lot of legal uncertainty about this, if you needed to get the consent of the author and under what conditions, etc. Now we have a data mining clause in the law, which allows you to use the data. The only condition is that you have legal access to the publication in itself. Well, I think there are a lot of open questions and a lot of things happening, and we are following on them, but I think it is too early to have definitive answers on how things will develop. I mean, yes, you've mentioned digital art. You see some of the art here in the office that is still for many people the reality, even if you have the possibility to have digital art. When it comes to copyright, there is discussion whether blockchain combined with small contracts would be a part of the solutions. I've seen private companies offering services. WIPO just initiated a new service called WIPO Proof. The idea was that you can, register your art that you have, and then you have a timestamp which allows you to prove that at this specific time you had possession of that specific piece of art. Now, whether this is really the solution, it's still to be open. It might help if you have a copyright infringement issue. At the same time, it is still not proof that you are actually the author of that piece of art. It just says that you had possession of it at a certain point in time. WIPO will actually suspend the service and no longer offer it. It is still being offered by private companies. So I think a lot happening, a lot to monitor and follow, and then we will have to see where it goes from here. Well, data and the IP system is a topic that has also been keeping us busy. We just published a report on it recently, and one of the questions we looked at is, do we need to amend the IP system to take into consideration this data issue that has been coming up, in the sense that data is the new gold and becoming more and more important. The free riding problem we discussed beforehand, which led to the patent protection, doesn't present itself in the same way with data. I mean, for one, data is usually a byproduct of another economic activity, and you can also protect it quite easily. I mean, you can, lock it, or you need a specific key to be able to use specific data. So I don't think we need to change IPR in the sense to introduce patent protection on data. Well, data seems to be a very important aspect of the pharma industry. I read an article recently about diet studies, saying that all the diet studies are nonsense because we do not really understand the link between nutrition and health, because every individual is different and would react differently. This brings us to a personalized medicine and what is the potential behind that. But for personalized medicine, you need a lot of data. Historically, pharma has always used a lot of data. I mean, be it already test data protection. This is a specific instrument that is adapted to the pharma industry, in addition, obviously, to all the patenting rights or trademark when it comes to protecting different medicines and how they are marketed to the public. In the future, I think this aspect is going to become even more important, and it will maybe, possibly, who knows, need amendments when it comes to IP rights, but maybe data protection laws or other developments. I mean, one of the difficulties is having access to the data. There, the aspect of data protection is important, but maybe also need some amendments to allow to use this data and use the potential that we have in this area when it comes to personalized medicine for the future. For us, it has kind of like two dimensions. The one is how can we use artificial intelligence within the office to simplify our work? Is artificial intelligence in a position to classify patents, or is it in a position to help us with the material examination of applications? It is also already being used when it comes to automatic translation of documents. And the other questions are more legal questions. What does it mean if it's not only a person that is inventing things, but you suddenly have this artificial intelligence that is inventing? So is it the person who invented the artificial intelligence that is the inventor, or is it the artificial intelligence itself? And what does it mean then on a legal level, in the sense that patent applications still require you to list an inventor? Currently, it can only be a physical person, but how do we deal with these situations in the future? This is a question that is not only a current one in Switzerland, but on a worldwide basis, in the sense that there is an invention that has been applied, or patent applications have been registered in several countries, and now we are following the developments on how each individual country is deciding on that question, whether a non-physical entity can be an inventor or not.